Hey, how you doing? This is Adam Post, publisher of more than 1,000 comic books and marketing expert covering woke nonprofits panic as lawsuits take on DEI. Let's get into the story. Before we do, please be sure you are subscribed to the channel. Click the bell for notifications. Give me a thumbs up. I really appreciate you guys. Coming from nonprofitquarterly.org, anti-DEI lawsuits threaten nonprofits and philanthropies. And coming from technical.ly, how organizations and allies stand up for DEI in a post-affirmative action America. Delaware Black Chamber of Commerce president. Delaware Black Chamber of Commerce. Yeah, there's actually a Delaware Black Chamber of Commerce. It's like a chamber of commerce, but you have to be black to be in it. How do these organizations think they're really going to be able to continue? I mean, blonde hair or not, you can't just have blonde hair and get away with everything. That's what these lawsuits are all about. Delaware Black Chamber of Commerce president Ayana Khan is one of the many speaking against recent anti-DEI lawsuits impacting businesses and entrepreneurship. Eventually, the Delaware Black Chamber of Commerce is going to have to be held to account for restricting membership and benefits of any kind of organization to people of specific skin colors or genders or sexual preferences only. That's not going to fly in the United States of America. You can go and create some racist state in another country if you want to, but not in the United States. And from Fortune, Musk says trying to make everything a race issue is divisive and corrosive, says days after settling a race discrimination lawsuit at Tesla. From nonprofitquarterly.org, anti-DEI lawsuits threaten nonprofits and philanthropies. The nonprofit and philanthropic sectors are at a growing risk for lawsuits challenging DEI, diversity, equity, and inclusion measures, fellowship and intern practices, giving and grant-making procedures, and even the provision of basic services. That's thanks to a new wave of litigation. It's not really thanks to the new wave of litigation. It's thanks to the fact that all of this discriminatory practice, regardless of what you say your intentions are, is completely illegal. And now you're being held accountable for it. Some of it already making its way through U.S. courts, seeking to challenge virtually any consideration of race in myriad institutional practices and decisions. Such are the warnings sounded by some legal experts as new legal test cases have mounted, challenging race-informed grant-making processes by nonprofits. Race-informed grant-making processes. So here's some free money to help you do what you want to do, but only if you're a certain skin color. In the wake of the 2023 U.S. Supreme Court decision ending affirmative action, thank you, Edward Blum, as practiced in colleges and universities, experts say these cases could be the tip of an anti-DEI legal iceberg for nonprofits and philanthropic institutions. Quote, a lot of our clients, whether they're nonprofits or for-profit companies, are facing a really different political landscape with regard to legal liabilities, says Ann O'Leary, an attorney for the Chicago-based law firm Jenner & Block, whose practice includes advising nonprofit organizations on these legal questions. If it's illegal, don't do it. You don't need a law firm for that. Even if you want to, this is how this stuff goes. Even if you want to do something illegal because you would feel good and maybe you could hurt other people when you do it and you like to hurt other people, you can do that too. But if it's illegal, don't do it. Just keep it as a fantasy and then you don't have any legal problems. Make a video game about it. But you can't do it in real life. The new uncertainty means some nonprofits and philanthropic institutions may have to grapple with difficult and potentially uncomfortable questions as they assess their own level of risk. Quote, many nonprofits do not have the resources, the ability sometimes, to deal with these fights, O'Leary warns. Jenner & Block's Marcus A.R. Childress, who chairs the firm's DEI Protection Task Force, says confronting such litigation could force nonprofits and philanthropies to face profoundly difficult decisions. The DEI Protection Task Force. Can you imagine if this was race sensitive, shall we say, in the other direction? The DEI Protection Task Force. With Jenner & Block's proud tradition of addressing high-impact social and equity issues in courts across the United States, and a passion for protecting diversity, equity, and inclusion in our society, our DEI Protection Task Force is at the forefront of assisting clients of all types as they navigate the impact of SFFA. And that's what this law firm is here to do. They're here to protect companies so they can continue to discriminate in any way they possibly can, even though it's really hopeless. But at least they can make some fees off of it. But what's more important to these nonprofits, to these companies, asked Childress? Is it doing the work they've traditionally done, or is it lowering the risk of litigation? How about just doing the right thing and also helping people? And at the same time, don't do anything illegal and don't discriminate against people based on their skin color, their sexual preference, their race, any of those things, not even religion. These legal attacks represent a very intentional effort to expand attacks on DEI. Yes, obviously, all of these test cases are all historic, and they are going to bury this racist approach to dealing with people who are not like you. We're getting rid of all of it. A wave of litigation. Much of the litigation brought to challenge DEI and other practices resembles that employed in a recent lawsuit brought against the Fearless Fund, an Atlanta-based nonprofit whose mission includes empowering African Americans to gain access to capital and which awards grants to business ventures only and exclusively to Black women. Literally on their website, they say, do not apply unless you are a woman and unless you are a woman of color. And they specifically say, not Asians. They don't count. They also aren't interested in Hispanics. The only thing they're unclear about is mixed race. I haven't seen them comment on mixed race. Of course, they're being sued by Edward Blum, who's the same guy who took out the illegal practices in affirmative action in colleges, so of course they're going to lose. The lawsuit brought in 2023 by the American Alliance for Equal Rights, headed by conservative activist Edward Blum, essentially argues that Fearless Fund's grant-making process amounts to explicit racial exclusion and is prohibited by civil rights laws. They're also suing another nonprofit, Austin, Texas-based Hidden Star, which awards small grants to women and minority-owned businesses. Both cases are currently pending in the courts. The lawsuits have attracted attention across the nonprofit and philanthropic sectors. In December 2023, the Council of Foundations and Independent Sector filed a joint amicus brief on behalf of the Fearless Foundation, arguing forcefully that philanthropic grants are protected under the First Amendment of the United States Constitution. The grants that the Fearless Fund gives are financed by outside public companies. They are grants, but they're also utilized to develop business relationships for the Fearless Fund's venture capital division. So they find a small entrepreneur, they say, hey, how would you like some free money? Are you the right skin color? Are you the right gender? Of course, here you go. Here's $10,000. Here's $20,000. They're small grants. But then they're able to take those relationships and then turn them into more serious commercial relationships by, as long as they are the right gender and skin color, which is Black and female, again, no Asians, no Hispanics, of course, no whites, they will then do a venture capital investment in that company if they like that person and they like the opportunity with that company. So the grants are really marketing opportunities for their venture capital fund. It's not really like a philanthropic grant, and they're also not a nonprofit. But even if they were purely a nonprofit, it's still illegal. You can't exclude people that way. I won't be making the decision on that. It's going through the court system, but it's pretty obvious you can't just discriminate against people unless it's some federally approved program that comes from the federal government that has its own sort of set of laws. Meanwhile, these legal attacks, notes Childress, represents a very intentional effort to expand attacks on DEI and race-informed initiatives beyond the narrow realm of affirmative action in colleges and universities, to which the Supreme Court's 2023 ruling was limited. But it really wasn't limited to just that. Many companies have realized, yeah, you can't discriminate the same way that you thought you could after that Supreme Court ruling. It's not necessarily binding authority. It's not necessarily a direct requirement ordered by the Supreme Court, but it's very persuasive and it's very informative. And corporate legal departments have taken notice and they've made a lot of changes. If you follow my channel, these cases and these lawsuits come up often. So definitely subscribe if you want to see more of that. Quote, it started with higher education, and we saw that play out with the Supreme Court this past summer. And then we saw a quick move to corporate diversity initiatives, says Childress. I think now what we're starting to see is the waves going from the corporate world now to the nonprofit space, the philanthropy space, grant-making activities, and it's using a lot of the same theories. Yeah, when you use a lot of the same theories because it's what the law is. So you're going to make constant references to the same civil rights law because this is a violation of civil rights law. Unwelcome challenges. The implications of these legal strategies for nonprofits and philanthropies could be profound. Among potential risks organizations face, says O'Leary, is the possibility of litigation that is not only incredibly expensive, but that can also drag the organization's name into a hostile media spotlight. So you get actually exposed for what you're doing. I do a lot of videos based on this subject. I usually do 1 or 2 videos a day. I've been doing this now for a couple of years. Honestly, I wasn't aware that there was a Delaware Black Chamber of Commerce. I didn't know that. I hadn't seen a story come up about it. No, there should not be chambers of commerce that are restricted to only certain skin colors or certain genders. We don't want that in this country. So yeah, you're going to get exposed because you're going to get a high-profile plaintiff like Edward Blum or like Stephen Miller from America First Legal, and there's going to be a lot of media interest, and yeah, your organization is going to get called out. A video I did that dealt with this company, the Fearless Fund, and another company, Hello Alice, talked about specifically how those companies are actually falling apart. That's how the Fearless Fund describes it. Quote, "It all fell apart. Fearless Fund founder on impact of DEI lawsuits. As conservative groups continue to go after DEI-based grant programs, the firms that provide them, including Fearless Fund and Hello Alice, are struggling, and they promise to fight back. She had 19 employees at Fearless Fund. She's now down to 6 employees, and they're having a very hard time raising money for their venture capital business, which is really what their main business is. Obviously, their main business is not giving out $10,000 and $20,000 grants. You're giving away free money. How do you make a profit at that? You make a profit at that because it's a loss leader, a lead generation service for your venture capital fund. And it's good publicity for your company and what your brand is all about. We give out money and we do business with Black women. That's all we do. That's our brand. Now invest in us or you're a racist. Okay, that worked for them, but it's not working anymore. People have had it with this kind of nonsense. Quote, all of a sudden, not only do you have your local news looking at you, but you've got Fox News after you, or MSNBC, or CNN. And that's a whole other ball game. You also have Adam Post on the Adam Post Speaks YouTube channel, and that's me. But in addition to that, the Fearless Fund founder went out and did a lot of publicity. She was on morning shows. She was on these major outlets. She was talking about what they do and why they do it. And all of that is not something they should be promoting that openly. What's amazing to me is, as a business guy, and I know Edward Blum is just looking to kind of set things right, I don't understand why the Fearless Fund founder doesn't just pick up the phone and say, "Hi, Edward Blum," or have her attorney do it. "Hey, you know what? We really want to still continue. We want to help entrepreneurs. We were trying to do the right thing. Would you please settle this lawsuit with us so that we don't actually get driven out of business for this nonsensical racist grant program?" Or at least in my opinion, what looks like a nonsensical racist grant program. Of course, they could help different people of different colors. And if they want to focus in one area instead of another area, they could do that too. But they want to be so blatant about it. But why not just settle with Edward Blum? He's a reasonable man. He'd like to take the win and not waste his time, and also go on and take on another organization instead of wasting his time on destroying the Fearless Fund. But these people are not that savvy. They're too focused on their ideology. Even nonprofit and philanthropic organizations that believe they can withstand such lawsuits based on legal merit alone can face uncertainty when it comes to the difficult decision to fight these cases out in court. Not least because the organizations face the prospect of the discovery process, in which sensitive internal policies and documents, for example, can become public. What do you mean discovery process? Discovery process is when you get involved in a lawsuit, the other side gets to kind of see your internal emails, documents, and correspondence. And if you've been saying illegal things in that correspondence, which it's possible they might have been doing in some of these lawsuits, all of those documents are going to become public. You're not just looking at losing a lawsuit, and you're not just looking at losing a business. You could lose your reputation if this trend of DEI doesn't last forever, and it doesn't look like it's lasting forever. Quote, even if we're on solid footing legally, which you're not, a Childress asks, is it worth to go through discovery to have so much sensitive information out in the public realm? That's a way of trying to talk sense into your client if you're an attorney, like, hey, we're not on any kind of solid ground legally. Let's pretend that we were. Is it really worth it to have your documents spread all over the world throughout the media when you know at least half, if not 80 to 90% of the country has not bought into this racial essentialism nonsense? For these reasons and others, standing on principle might not be such an easy decision for many organizations. But I think there are many people who feel strongly that they don't want to and shouldn't make changes because they want to ensure that they're reaching the most vulnerable and disadvantaged members of our community, says O'Leary. But then there are others who are saying, I don't know if we can withstand a fight like that. No, you can't. If you're involved in an organization like this, and I think people probably have good intentions. I don't think there's evil in people's hearts like that. I'm a really optimistic guy that way. Let me tell you, whoever you think you are, you will not and you cannot withstand a battle with Edward Blum, who took out Harvard and a lot of other high-powered political influences on the affirmative action case. If he thinks he has a case with you, he's not going to lose that case. Similarly, Stephen Miller, you're going to take on Stephen Miller in a lawsuit and say, I don't don't care about America First Legal. I'm going to discriminate because I think it's the right thing to do. Do not take on Stephen Miller from American First Legal. Who's Stephen Miller? That's this guy, President Trump's right-hand man when it came to fighting back illegal immigration policies. He now runs America First Legal, and he's suing the butts off of a few companies and terrorizing other companies with federal employment complaints that are having a major effect on industry at large. Public companies, small companies, all kinds of companies and organizations. If you see the name Stephen Miller, settle immediately. Do not fight a fight you cannot win. O'Leary continued on to note that the Fearless Fund and Hidden Star lawsuits are not going to be the only test cases. They will pick others. So what can organizations do? The current landscape of challenges to DEI and other race-conscious practices remains highly uncertain for nonprofits and philanthropies. Meanwhile, the latest legal cases wind their way through the courts, likely, say Childress and O'Leary, on their way to the Supreme Court. But the lawyers say that beyond simply monitoring the progress on these cases, there are steps such organizations can take now. Though O'Leary acknowledges, quote, that's not a clear path, and so we're trying to help our clients think through that. One step some nonprofits and philanthropies can take is to prepare for the potential of litigation by undergoing an internal risk assessment. But we're definitely suggesting those types of audits to understand where your vulnerabilities are, says O'Leary. Because I think the most important thing to know is what you'd do if you were attacked, or if a lawsuit came for you holding you accountable, or attacked, however you want to look at it. Other potential routes of action involve reevaluating existing policies or programs that can be harmed by future rulings. For example, by changing the focus of a grant-making program to focus on economic disadvantage rather than race, which is a protected class under the law. So stop being so racist. That's what the lawyers are saying. Also, I'll give you a little advice. Destroy documentation that you have that expose that you're committing crimes. And then stop committing crimes altogether. That's free legal advice from me. I'm not an attorney. I'm just saying stop doing illegal things and then destroy the evidence of things that you've done that are clearly illegal. But such moves, the lawyers acknowledge, can themselves risk undermining the very mission and purpose of the organizations in question, forcing nonprofits and philanthropies to grapple with existential questions about their priorities. What I think is really important, O'Leary says, that the nonprofit sector understands and begins to wrap their head around this. The attorneys understand exactly what's going on because they're sophisticated. They also know a lot of this stuff was never legal and never close to legal in the first place. The attorneys are acting as therapists to try to help you think through how can you stop doing such illegal stuff. Now, I'm not saying that any of these people are doing illegal things. It feels to me as a non-lawyer that a lot of these things are incredibly discriminatory. I also have a lot of faith in Stephen Miller and Edward Blum. They're not going to waste money and time on cases if there's really nothing there. So I can't say it's illegal, but it does feel illegal. And from the comments made by these attorneys that are trying to have a DEI protection task force and protect these companies and organizations, of course, companies and organizations are freaked out because they see these high-profile lawsuits, and you see like the founder of Fearless Fund, and later in this article, Hello Alice says the same thing, saying, hey, this is incredibly damaging our business. Maybe we shouldn't be in this lawsuit. It's driving us out of business. Hello Alice also lost the opportunity to raise Schedule C funding, which is funding for companies that are ready to kind of explode and grow in a good way, not explode and collapse in a bad way. Hello Alice lost their investors. The Fearless Fund lost their investors. And of course, if you're an organization or a business that's focused on discriminating against certain people, supposedly to the benefit of other people based on their skin color or their gender or their race or their religion or sexual preferences, it's not a good thing to be doing right now. So yes, you can pay an expensive law firm to tell you at $500 an hour, hey, you better start destroying some documents. You better start changing some of the language on your websites. Just obviously cut it out with the stuff that's, quote, race inclusively conscious or whatever the language is. You know what you're doing. Stop doing that. Come right with the law. And if you get a phone call from Edward Blum or Stephen Miller or one of their attorneys, settle immediately. Ask them what you can do to solve the problem. Get on the same side of the table as those guys. Don't get dragged through the courts and destroy your businesses. It's not worth it. You don't have to discriminate against anyone to try to help everyone. Let me know what you think of all this in the comments below. Always love to see your ideas. Please be sure you are subscribed to the channel. Click the bell for notifications. Give me a thumbs up, and I'll see you again soon with another story. And if I don't see you, I will miss you.